Okay, let's unpack this. Welcome back to the deep dive. You are a diligent learner, sent us some really interesting source material. It outlines, well, a monumental journey, doesn't it?
It really does. A 10-volume scholarly work, 50 sub-volumes, all focused on the foundations of Islamic jurisprudence, prophetic and caliphal legal precedents. The scale alone is quite something.
Absolutely. But what grabbed me, and I think what grabs the source material itself, is how it's framed. It's not just history for history's sake.
Not at all. It's presented as, well, a direct contribution to today's legal and ethical debates. That's the core claim.
Exactly. They pose this really arresting question, don't they? Can legal wisdom from 1400 years ago, based on actual decisions by leaders back then, can it genuinely guide us now?
And specifically, in this era we're entering, the AI-driven era, in our courts and shaping global ethics, even structuring these new digital economies that are emerging, it's a huge question.
That really is the mission statement here, isn't it? So we're diving into the claims, the structure of this massive resource. It's presented under this banner, AIAW AI Era Islamic Abrahamic Wisdom.
Mhm.
Our job, really, is to understand the framework they're building and, critically, why they believe it offers a practical, almost actionable blueprint for today's ethical problems. It feels like it wants to be more than just history.
Oh, definitely. And to make that case for modern utility, they're very specific about their sources. They focus almost exclusively on judicial decisions, actual living precedents.
That by whom specifically?
Two key periods. First, the foundational rulings of Prophet Muhammad himself. And second, the way those rulings were applied and administratively developed by the rightly guided caliphs, Abu Bakr, Umar, Uthman, and Ali.
Right.
So the objective for you, the learner, is to see how this framework supposedly laid the foundations of Islamic law. And the sources characterize this law as a system that kind of masterfully balanced faith with reason, and how that whole established methodology, that way of thinking, is meant to offer practical guidance for all the complexity we face today.
Okay, let's start right there at the historical root. You said it's focused on practical decisions, not abstract theory later on. Why is that distinction so important for their argument about modern relevance?
It's absolutely crucial because it frames the system as one forged in, well, executive experience, real-world necessity.
Yeah.
These weren't academics in a library centuries later, right?
Right.
These were rulings made on the spot by leaders who were simultaneously acting as heads of state,
Yeah.
chief judges, sometimes even military commanders. They were dealing directly with conflict, social issues, economic needs.
So they were living precedents, as the source material puts it, applied immediately.
Yes, exactly. Applied across every facet of daily life. You have to picture it.
Give us a sense of that. Where would you see these precedents in action back then?
Well, think about everywhere. A modern state needs structure. They were applied in the courts, settling disputes between merchants or setting standards for family arguments.
Yeah.
They were used in marketplaces, establishing weights, measures, rules for fair trade.
Okay.
They defined rights within homes, family law, and significantly, they even established codified rules of engagement, ethical conduct, during warfare on the battlefield.
Wow.
So it represents this really rapid, active creation of a functioning, pretty sophisticated legal order built from the ground up on real-time decisions, not just legal philosophy for the future.
And this is where the source material makes some, frankly, enormous claims about the impact, calling these decisions monumental historical achievements that shaped civilization. Let's get specific. The institutional precedents, starting with the Constitutional Charter of Medina, that's a big claim.
It's a very big claim. The source material flat out asserts that this charter, drafted around 622 CE, was the first written constitution in human history.
Okay, that's a high bar, as you said. What makes it a constitution, in their view, rather than just, say, a law code like Hammurabi's or something earlier?
Yeah, good question. Their argument hinges on its purpose and structure. They argue it wasn't just a list of laws handed down by a king. It was framed as a political contract.
A contract between who?
Between diverse groups, the different Muslim groups, yes, but also the Jewish tribes, Christian communities, various Arab tribes in Medina, all living together under one political authority, the Prophet.
Ah, so it defined rights and responsibilities for a pluralistic community.
Precisely. It defined mutual obligations, rights, responsibilities within this mixed community, this ummah. The implication is huge. Structured, written governance, defining limits and duties for everyone, wasn't based on just tribal loyalty or shared religion alone. It was based on this explicit, documented agreement. That set a precedent for political organization by consensus.
Okay, that's foundational. And building on that structure, the sources highlight something maybe even more radical for that time: judicial accountability, even for the
Mhm.
leader.
This might be the most critical piece for establishing genuine rule of law. And, it resonates deeply with our modern worries about unchecked power, whether it's political or increasingly algorithmic.
How so?
The sources really stress this. The judicial system was set up from the start with the clear precedent that no one was above the law, and that included the highest political authority, the caliph himself.
That's hard to fathom given the context of 7th century autocratic rule elsewhere. How did that actually work? Did a caliph really have to appear in court?
There are historical accounts cited, yes.
Mhm.
The system deliberately separated, to an extent, the executive and judicial roles. There are famous precedents, like one involving Caliphal.
What happened?
Well, the story goes he had a dispute with a Jewish citizen over a lost piece of armor. Ali believed it was his. The citizen claimed it was his. The case went before a judge technically appointed by Ali. And Ali had to appear before the judge, present his case like any other citizen. In that particular instance, the judge actually ruled against the caliph because Ali couldn't produce sufficient proof according to the standards of evidence.
The caliph lost the case.
According to that precedent, yes. But the specific outcome is less important than the mechanism. The fact that the head of state submitted to the court's judgment, that's what cemented the legitimacy. It showed the law, not the ruler, was supreme. It prevented the legal system from just being a tool of state power.
That idea, the ruler submitting to the judge, that's an incredibly potent precedent when you think about modern systems, maybe AI systems, that operate with a lot of unchecked discretion.
Absolutely. The parallel jumps right out, doesn't it? If a human leader overseeing a vast state needed institutional checks and balances, then surely an autonomous system operating on complex, often opaque data, well, it definitely needs them too.
Okay, so governance structure, top-level accountability. What about the social fabric? The sources mention early social structures built into the law itself, not just punishment or contracts.
Yeah, right. It wasn't just about keeping order or facilitating trade. The legal and governance structures were designed, from the outset, to foster a sense of collective responsibility and build, essentially, a foundational social welfare model.
How did that manifest in law?
The most prominent example, and it was rigorously enforced, was zakat, obligatory charity. This wasn't just suggesting people be generous.
It was a tax.
Effectively, yes. A systematized annual collection calculated based on specific types of wealth savings, trade goods, livestock, agricultural produce above a certain threshold. And it was designed specifically to circulate wealth, prevent poverty from becoming entrenched, and it was managed and distributed by the state apparatus.
Managed by the state, so it wasn't just private charity.
No, it was institutionalized. The state collected it and distributed it according to clear categories of need defined in the Quran. It was a core function of governance.
What else fell under this early welfare concept, besides zakat?
The sources point to precedents suggesting communal and state responsibility for other essentials. Things like access to basic health care, ensuring education was available. The underlying principle was that the state had a direct role, a legal obligation, for the well-being and upliftment of all citizens.
So the law wasn't just reactive, settling disputes. It was proactively shaping society.
Exactly. It aimed for ethical, socioeconomic outcomes, not just legal order. That's a profound idea embedded early on.
Okay, internal governance, accountability, social safety nets. But states don't exist in isolation. What about dealing with the outside world? Foreign policy, diplomacy.
That's another major area the sources highlight. The legal framework established what they call a distinct foreign policy of justice. This wasn't ad hoc. It was systematic statecraft.
What were the key elements?
A heavy emphasis on formalized diplomacy. Drafting treaties, for example, was taken very seriously. And crucially, once a treaty was ratified, it was considered a binding, inviolable obligation.
Even if circumstances changed later.
That's the precedent highlighted. Breaking treaties was a major violation. This principle aimed to build trust as the ultimate currency in international relations. Consistency was key.
Makes sense. What else?
Formalized diplomatic relations with neighbors, sending envoys, and perhaps critically for that era, establishing and respecting diplomatic immunity.
So ambassadors were protected.
Absolutely. Harming an envoy was seen as a grave offense against the law of nations, essentially. This whole sophisticated approach showed the legal system wasn't just internal. It could operate on a global stage with predictable ethical rules. It set a standard for how this emerging state would interact with others.
It paints a picture of a very comprehensive system being built very quickly. And that sets up the core argument, doesn't it?
Hmm.
That because these foundations were so broad and deep, they might actually be applicable beyond their original time and place.
Precisely. That's the claim we need to explore now, why this history is supposed to matter today. Right, so this brings us smack into the justification for this whole massive project. Why should you, the learner today, care about a super detailed 50 sub-volume analysis of 7th century legal rulings?
Well, the authors paint a picture of our modern world as being defined by, frankly, radical instability. And they seem to argue that current, mainly secular legal systems are struggling to keep up.
They identify some key stressors, don't they?
Yeah, four big ones that are all tangled together. First, the sheer disruptive speed of artificial intelligence. Second, globalization, its power to connect, but also to destabilize and shift geopolitical landscapes. Third, just pervasive political turmoil and instability. You see it everywhere. And fourth, maybe underlying it all, a sense of deep moral uncertainty.
And the argument is?
The argument seems to be that these modern challenges trying to define AI ethics, harmonizing laws across cultures, managing political polarization, finding a solid moral anchor, they're so complex that purely modern or purely secular or even novel regulatory fixes often feel, well, inadequate. They lack historical depth or maybe proven staying power.
Okay, so where does the 7th century come in?
The premise, as presented, is that these specific historical precedents, the Prophetic and Caliphal ones, offer timeless guidance. Why timeless? Because, the argument goes, the early Islamic State itself was born and consolidated during a period of intense social, political, and cultural upheaval. They had to manage rapid change, too.
Timeless guidance is a strong claim. It seems to rely heavily on that idea of synthesis we touched on earlier, this legacy of balancing faith and reason.
Exactly. That synthesis, achieved through a specific methodology, seems to be the unique selling proposition here. The authors argue this body of law shaped civilization precisely because it sought this balance.
How did that balance work in practice?
Well, the ultimate source of law was divine revelation, the Quran and the Prophet's example. But its application, the day-to-day work of judging, governing, setting trade rules that was heavily informed by human intellect, aql, practical necessity, critical thinking, and adapting to changing social realities, earth.
So it wasn't just rigid adherence.
Apparently not. This methodology, which they say is rooted in justice, adala, compassion, rahma, and divine wisdom, hikmah, aimed to make the law both firm in its core principles, yet flexible enough in its application to handle real life.
That flexibility is interesting. Modern law often struggles there, doesn't it? We create rules that are either too rigid for new tech or so flexible they don't offer clear ethical lines.
Right. So what does this historical method mean for today? The authors pivot pretty quickly from history to essentially offering a blueprint.
A practical blueprint.
That's the goal. A framework that's practical enough to actually address contemporary challenges. So when modern regulators or courts or tech companies wrestle with fundamental questions like, how do we define fairness in an algorithm? Who's accountable if a self-driving car crashes? How do we build stable global financial rules? The authors are basically saying, look, this early Islamic legal system developed a tested methodology for balancing innovation and change with solid ethical principles. We should look at how they did it.
So the argument is, if this system could take diverse, warring tribes, different religions, and forge them into a stable constitutional state with serious internal and external accountability,
and do it really fast, within decades,
then the methodology used must have some serious rigor. Enough rigor, perhaps, to handle the speed and ambiguity of the AI era.
It's definitely a compelling case for methodological endurance, not just historical facts. They're offering not just knowledge, but maybe a kind of tested operating system for managing complexity.
Which brings us to the structure of that operating system, the 10 fields. Exactly. Now we get to the sheer scale. The architecture that's meant to prove this system was truly comprehensive and therefore potentially relevant across the board today.
10 fundamental fields of Islamic law. And within those 50 detailed subvolumes, you really need that kind of scope, I suppose, to back up the claim that this covered everything from personal prayer to state finance. We need to walk through this structure because this is the heart of their evidence for modern utility, isn't it?
It absolutely is. We should go through them, maybe not exhaustively, but detailing the core content promised for each field and really emphasizing the concepts the authors believe connect directly to modern legal issues, especially around AI and global challenges.
Okay, let's dedicate the time. Field number 1, constitutional law. Where does that start?
1, constitutional law. Okay, this is foundational. It draws heavily, as we discussed, from the precedents of the Medina Charter. It focuses on how the Prophet and Caliphs actually established the structures of governance.
What kind of
Things like the mechanisms for consultation, shura, how leaders were expected to seek counsel. It defines the limits of executive power, a crucial point. And it enshrines the implementation of justice, adala, as the primary, non-negotiable purpose of having political authority in the first place.
So power wasn't just for power's sake.
The precedents highlighted suggest political legitimacy was explicitly tied to delivering justice. If a ruler was unjust, their legitimacy was questionable.
How does that connect to modern constitutional debates or even AI governance?
Well, for modern learners, the author suggests this offers models. Models for drafting inclusive charters, especially in diverse societies. How do you preemptively manage political organization to protect everyone's rights?
Okay.
And crucially, it provides a strong historical precedent for limiting executive power. That's vital when governments are deploying powerful, often opaque technologies like AI surveillance or autonomous decision-making systems.
So the historical requirement for consultation, shura, could inform modern calls for
Mandatory public engagement, expert review boards before rolling out major AI systems. Exactly. It offers a historical basis for insisting on checks and balances against potentially unchecked technological power used by the state.
Got it. Okay, field 2, criminal law. This often gets a lot of attention, and the terms can be complex.
Criminal law. Yes, the source material outlines 3 distinct categories here. It's important to differentiate them. First, you have hudud.
Which are?
These are fixed penalties, explicitly mentioned in the Quran or Sunnah, for a small number of specific crimes, things like theft, adultery, defamation, under strict conditions. The rationale is often described as protecting essential societal interests, like property, family lineage, public order. The conditions of proof are extremely high.
Okay, fixed penalties. What's next?
Second, there's qisas. This often translates as retaliation or equality, particularly in cases involving physical harm or homicide. The key here is strict proportionality, an eye for an eye, conceptually. But the legal procedures are meticulous. And crucially, qisas often emphasizes the rights of the victim or their family, who might have the option to forgive the offender or accept monetary compensation, daya, instead.
So there's an element of victim agency and potential reconciliation built in.
Yes, that's often highlighted. It's not just about state punishment. Then the third category, which is perhaps most relevant for adaptation, is tazir.
Tazir, what does that cover?
This refers to discretionary penalties. It covers basically all offenses not covered by hudud or qisas. And here, the judge has significant latitude.
Latitude to do what?
To determine the appropriate punishment based on the specifics of the case. The context, the offender's circumstances, the harm caused, the potential for deterrence, the public interest. It could range from a warning to fines, imprisonment, or other measures.
Why is this flexibility so vital for the modern relevance argument?
Because tazir is inherently adaptable. The authors argue this is precisely the kind of legal category needed to deal with new types of crime emerging today: sophisticated cybercrime, complex financial fraud, AI-enabled harms, things the original texts couldn't have envisioned.
So the precedent of Tazir offers a model for judges or regulators needing flexibility within clear ethical bounds.
Exactly. It allows the law to evolve and address novel harms without needing entirely new legislation for every permutation. It builds in judicial wisdom and context.
You also mentioned rehabilitation being part of this.
Yes, the source material emphasizes that the goal wasn't solely punitive across the board. Precedents are cited that focus on mechanisms for rehabilitation, correcting behavior, restoring the offender to the community. This connects strongly to modern restorative justice ideas, showing that even a divinely rooted system prioritizes repairing harm, not just inflicting punishment.
Okay, let's move to the bedrock of society. Field 3, family law.
3. Family law. This is obviously critical for social stability. The sources indicate this field meticulously covers the legal foundations of the family unit.
What aspects specifically?
It details the nature of marriage as a contract, the procedures involved. It lays out precise rules for divorce, including the financial and other rights of both spouses during and after the marriage ends. Inheritance laws are also a major part, codified rules for distributing estates, designed partly to prevent wealth from concentrating arbitrarily generation after generation.
And guardianship.
Yes. The rules surrounding guardianship, wilaya saga, for minors or for adults deemed legally incompetent. Who is responsible? What are their duties? How is the ward's interest protected?
Seems quite comprehensive. But how does 7th century family law speak to the AI era? That connection feels less obvious.
The argument here is about foundational principles: clarity, defined rights, stability. In an era of rapid social change, maybe driven by technology,
Yeah.
having clear foundational rules for the basic social unit becomes even more important.
Can you give an example?
Well, consider the meticulous rules on inheritance or guardianship. The authors suggest the methodological rigor used there, the way rights and responsibilities were precisely defined, could inform how we approach complex modern issues. Things like digital inheritance. Who owns your data, your digital assets, your online identity after you die?
I see. Or digital guardianship.
Exactly. If someone becomes incapacitated, who manages their digital life, their finances online, their social media presence, the historical emphasis on clearly defined rights and responsibilities within families provides a potential framework. The focus on marriage as a clear contract also provides a model for thinking about social contracts more broadly, ensuring basic human rights aren't eroded by tech shifts.
Okay, that makes sense. Moving to the economy. Field 4, commercial law. This seems immediately relevant to global issues.
4. Commercial law. Hugely relevant. This field established the ethical rules for the marketplace for economic life. It covers accepted trade practices, honesty, fairness, standards for quality, weights, measures, and the absolute necessity of clear, formalized contracts to build trust and ensure accountability.
And the really distinct part is Islamic finance, right? Riba and Gharar.
Yes, those are central. The precedents established here detail the prohibitions against riba, often translated as interest, or usury, and gharar, excessive uncertainty or ambiguity in contracts.
Can you unpack those a bit? What's the function of prohibiting riba?
Riba fundamentally prohibits earning a profit just from lending money, without taking on any real economic risk related to an underlying asset or venture. It enforces risk sharing. Instead of debt-based financing where the lender gets paid regardless, Islamic finance models typically involve partnership, equity stakes, or asset-backed transactions where both parties share the potential upside and downside.
And Gharar, excessive uncertainty.
Gharar prohibits contracts where key elements are unknown, ambiguous, or depend purely on chance, like gambling. It aims to prevent speculation and exploitation based on informational asymmetry. Think complex derivatives, where the underlying value is obscure.
How does this ancient prohibition connect to today?
The source material argues pretty forcefully that these principles were designed precisely to create economic stability and prevent the kind of speculative bubbles, debt crises, and systemic collapses we've seen repeatedly in modern global finance. They offer this as a tested, alternative model, risk-sharing, asset-backed finance rather than debt-fueled speculation.
That contrast is definitely stark, especially when thinking about financial regulation.
And it links back to AI, too. If an AI-driven trading algorithm is based purely on high-frequency speculation with no underlying value creation, high gharar, the historical precedent would question the ethical and even legal soundness of such a system from the outset.
Interesting. Okay, next, owning things. Field 5, property law.
5. Property law. This defines rights over resources, land, goods, maybe even intangible things. It details concepts of individual ownership, how property rights are acquired and transferred, rules governing land use. But the most unique and potentially relevant concept here for modern structures is the institution of Waqf.
WACF, W-A-Q-F. Can you explain that? It's not like a standard Western trust, is it?
Not exactly. A Waqf is essentially a perpetual irrevocable endowment. Someone takes an asset, land, a building, maybe even money, and dedicates it permanently for a specific charitable, religious, or public benefit purpose.
Permanently.
Yes. Once declared a Waqf, the ownership of the asset itself is effectively frozen. It's taken out of private hands, it can't be sold or inherited. Only the income, the fruit, the usufruct generated by that asset can be used for the designated purpose.
Give me an example.
A ruler might dedicate a plot of land with a well as a Waqf to provide free water to the community forever. Or dedicate rental income from a building to fund a school or a hospital in perpetuity. The asset itself is preserved, protected from the market or family disputes, to serve its purpose across generations.
That sounds incredibly relevant for modern ideas about, say, creating permanent public goods or structuring long-term philanthropy or even protecting things like open-source knowledge commons.
Absolutely. For modern legal systems thinking about how to structure charitable trusts, foundations, land trusts for conservation, or even digital archives meant to last forever, the Waqf offers a unique, historically tested legal model for ensuring long-term dedication and preventing the erosion of the core asset over time. It institutionalizes intergenerational benefit.
Fascinating. Okay, shipping back outside the state. Field 6, international law, how the state deals with other states.
6. International law, or CR. as it's sometimes called in classical terms. This field is quite comprehensive, detailing the rules for statecraft that emerged as the early Islamic state expanded and interacted with neighbors like the Byzantine and Persian empires.
What did it cover specifically?
The necessary procedures for drafting and, again, honoring treaties, mechanisms for formal diplomacy, negotiation, sending envoys, we touched on immunity, but critically, it also detailed rules governing the conduct of both war and peace. Jihad in its broader sense, but also the specific roles of engagement in conflict.
The source emphasizes legal constraints on warfare.
Very much so. Constraints based on prophetic instructions and caliphal practice. Things like proportionality of force, the strict prohibition against treachery or mutilation, and especially the protection of non-combatants.
Who counted as a non-combatant?
Explicit protections were mentioned for women, children, the elderly, monks or priests, farmers not engaged in fighting, anyone not directly participating in hostilities. By detailing these early precedents, the authors aim to provide a robust historical framework for modern debates on military ethics.
Especially relevant with things like drone warfare or autonomous weapons.
Exactly, defining non-combatant status in complex asymmetrical conflicts. The precedents emphasize that even in wartime, state violence is subject to codified law and ethical constraints. It's not a lawless space.
Makes sense. Okay, you need machinery to run a state. Field 7, administrative law.
7. Administrative law, AIAW. This defines the functions of the state apparatus itself. How does the government actually work? It covers the governance structure roles of governors, ministers, judges. It details systems of taxation, which crucially had to be seen as just, codified, transparently administered, not arbitrary.
And the civil service.
Yes, the organization of the Diwan, the civil service or bureaucracy. The historical model emphasized competence and meritocracy, ideally over tribal connections or nepotism in appointments. It focused on efficiency, clear record-keeping, and importantly, accountability for state officials.
Accountability for bureaucrats? How?
The sources cite precedents where officials, like tax collectors or administrators who misused their position or funds, faced swift judicial or executive action. The aim was to minimize corruption and maximize state effectiveness through clear responsibilities and institutional integrity.
How does that connect today?
Directly to modern issues of government transparency, fighting corruption, and ensuring fairness in public administration. And crucially, when thinking about algorithmic governance, AI systems, making decisions about resource allocation or service provision, the historical insistence on clear lines of human accountability for administrative actions becomes very relevant. Who is responsible if the algorithm gets it wrong?
Right, okay, the engine room of justice itself. Field 8, judicial law.
8. Judicial law. Kata. This covers the actual mechanics of the justice system, the rules governing the courts themselves, defining the standards for admissible evidence, what counts as proof.
What did count as proof?
Things like credible witness testimony with specific requirements, oaths, written documents, confessions under certain conditions. It also covered the system for appeals and formal mechanisms for dispute resolution outside of court, like mediation or arbitration. The emphasis was always on ensuring access to justice, impartiality of the judge, qadi, and due process.
How does 7th century evidence standards inform debates about AI in the legal system? That seems like a leap.
It raises fundamental questions about verifiability and transparency. Early Islamic law, according to these sources, insisted on evidence that could be examined and challenged human testimony, clear documents.
Okay.
This historical insistence on transparency really challenges modern systems that might rely on proprietary black box AI algorithms for things like predicting recidivism risk for sentencing, or deciding bail applications, or even allocating social benefits.
Because you can't cross-examine the algorithm.
Exactly. Or easily audit it for bias baked into the training data. The authors argue the historical rigor forces us to ask, if early law demanded clear, challengeable evidence, how can we justify using systems where the reasoning is opaque and potentially unappealable? The precedent demands evidential transparency.
Got it. Field 9, social welfare law. We touched on zakat, but this expands on it.
9. Social welfare law. Yes, this field elaborates on those collective responsibilities mandated by the state for the community's well-being. It details the administration of zakat as a formal, institutionalized safety net, but it goes beyond that.
To include what?
The sources outline foundational rights related to universal access to education, provisions for public health, and, very significantly, labor rights.
Labor rights in the 7th century. That sounds quite modern. What kind of rights?
The foundational precedents cited focus heavily on protecting workers from exploitation, things like clear mandates for fair wages, ensuring payment was made on time, providing reasonable working conditions, setting limits on excessive workload or mistreatment of employees or slaves.
Why is that significant?
It demonstrates the holistic nature of the law. Economic activity wasn't seen in isolation. It was fundamentally linked to human dignity and required codified protections. In today's world, with the gig economy, platform work, concerns about automation displacing workers, this historical precedent of prioritizing the worker's dignity and ensuring fair compensation offers a potentially powerful ethical framework for developing modern labor laws and regulations.
Okay, one field left. The 10th. Religious law.
Religious law. This covers the relationship with the divine and also between different faith communities. On a personal level, it details practices related to worship, ibadat, prayer, fasting, dietary laws, the pilgrimage, the structure of religious life.
And the intercommunal aspect?
Yes, and this is very relevant sociologically and politically today. It covers the establishment of comprehensive rules for interfaith relations, how the Muslim state legally related to non-Muslim communities living within it.
What was the legal position, according to these sources?
Building on the Charter of Medina, the precedents established by the Caliphs focused on coexistence. This involved legally protecting non-Muslim communities, dhimmis, guaranteeing their freedom of worship, protecting their churches or synagogues. It also defined the legal parameters for their communal autonomy, often allowing them to use their own religious laws and courts for internal civil matters, like marriage or inheritance, within the broader state framework.
So institutionalized legal pluralism.
To a significant extent, yes. For a world still grappling with religious intolerance, political radicalization, and the challenges of managing diversity in multicultural societies, the authors present this historical model of legally protected pluralism and managed diversity as potentially valuable framework for thinking about modern laws governing interfaith relations.
Okay. That walkthrough really does paint a picture of a comprehensive, deeply integrated system. It wasn't just one thing. It aimed to cover, well, everything.
That's the core argument. It wasn't just a niche legal theory. It was presented as a complete operating system: political, social, economic, ethical, spiritual.
And the synthesis, the application promise, is key. Each of those 50 sub-volumes, the source promises, will bring out real cases, actual historical precedents, and timeless lessons that they argue are directly applicable now.
Right. They're not just saying this is interesting history. They're saying this is actively useful for drafting laws today, for setting up ethical AI frameworks, for informing how judges reason about justice. And not just in Muslim-majority countries, but anywhere grappling with these fundamental questions of law, ethics, and technology. #tagoutro. So we've really taken a deep dive today, haven't we, into this monumental undertaking, exploring how this work aims to synthesize prophetic and caliphal jurisprudence across 10 vital areas of life and law, from how you structure a state to how you treat your neighbor, to how you conduct business or even wage war.
And the significance, as the authors frame it, is that this isn't just a historical record. It's positioned as a living dialogue, a conversation between revelation, reason, and the challenges of modern law. They're asserting that this deep legal wisdom, forged in that initial crucible of applying faith and logic to practical problems, is not only available but necessary for tackling the complexities we face now.
The aspiration they state is very clear. The hope is that this body of jurisprudence can genuinely inspire justice systems worldwide, provide a model for governance that is comprehensive, ethical, accountable, and perhaps most critically for our times, help shape how we apply ethics in the AI era. That focus on fairness, accountability, systemic justice, that's what they see as essential for navigating powerful, autonomous technology.
Which brings us neatly to our final provocative thought for you, the listener, to chew on. Building directly on everything we've explored, the source material hammers this point home again and again. A foundational achievement of this early system was establishing a judiciary where no one, not even the caliph, the absolute ruler, was above the law, forcing transparency, forcing accountability.
It's such a powerful historical precedent for constitutional limits on raw power, isn't it?
Yeah.
So the question we want to leave you with is this. Given that deep historical insistence that accountability must be institutionalized, that it must act as a check even on the highest human authority, how should that tradition, that insistence, translate to our modern challenges?
Specifically, the immediate pressing need for algorithmic transparency, for clear ethical frameworks, and for verifiable legal accountability when we're dealing with these increasingly complex, autonomous, and rapidly evolving AI systems.
If the caliph needed a judge to hold him accountable,
Shouldn't the algorithm? Something to think about until our next deep dive.